So back to mention item number 29. Well, today while checking, I found out inadvertently that affidavit in reply has not been filed. Only give me 2 weeks.
Item
29, madam.
29.
Madam, please give me 2 weeks time, madam. I'll file the reply and then, madam.
2012 matter.
Yes, my lord. Somehow it has not been listed also, and inadvertently, my lord, it has escaped my attention, my lord. 2 weeks time only, my lord. That is
We
all
are granting you adjournment. We not say because if you file an affidavit in reply, now in affidavit in reply.
my lord. But that is necessary, my lord. Some factual aspects are there, my lord. That is necessary to be, my lord, countered.
Who's for the other side?
The state appears, my lord. The Union of
All
India.
right. Matter item 29 adjourned for 2 weeks.
And
The request of Mr. G. Chaudhary, learned counsel for the petitioner, to enable him to file a reply affidavit. So now, once the matter is fixed for hearing, there is no question of filing any pleadings. That is why it is fixed for hearing.
That is therefore inadvertently, my lord, I had seen my lord.
All right, all right.
Mistakes here and there.
May I please look? I am appearing for item number 19, 20, 21, 22. We have filed a IAS prayer for calling for the IAS.
All right, call for the IS. Note effect 1920. It is from item 18.
19.
No, 18.
Yeah, but we have from.
All right, all right. You give the requisition to the court master.
May I please, Lordship? Lordship, for listening to petition for admission, Lordship.
Hmm?
I think the appointment of Pradhan for admission, Lordship, next week.
Not next week, December. Let come on.
If some urgency is there, Lordship,
Maybe in when is the matter? When was the matter filed?
file long back, Lordship.
When?
One is 22, one is
When? Which year?
22, 118 matter.
22. 2018.
Yes, one is 18, one is 20.
So you have it in December.
Lordship, December 1st week.
7th December.
Oblige, Lordship.
Sorry. 18 December. 18. 18 December.
May I please, Lordship? I beg to mention item number 33. Hearing matter. What the matter may probably be in flux. Since last several years, the petitioner is not contact with the
You are Mr.
B. Gogoi.
Mr. B. Gogoi, learned counsel for the petitioner, and the instruction submits that the writ petition has become infractuous. Accordingly, the same stands dismissed as not pressed. Interim order, if any, stands vacated. Pending I is also dismissed. Yes.
Lordship, my senior counsel suddenly fell sick, Lordship.
Huh?
My senior counsel had suddenly fell sick, Lordship.
Oh, who's your senior?
RKT Chaudhary.
Oh,
Kindly fix the matter on 4th of December, Lordship.
Well, short date may be given, but I have because
fourth. He's asking for fourth.
I am in hanging position, well, because the person who have transferred in my place has already been joined.
We'll have it on 8th of December.
Well, prior to that.
Prior to that, there is no.
Fourth December.
Fourth, we already have several matters. 8th of December. Take care.
The only problem is that I am in hanging position. That's the problem.
We'll take care of that. 8th of December. 8th of December, please inform him. No further adjournments.
He suggested me 4th December, Lordship.
4th December. All right, 4th December then. List on 4th of December at the request of Mr.
M. Rana.
M. Rana, who submits that the arguing counsel, Mr. R.K. Dev Chaudhary, learned DSGI, is indisposed today and seeks an adjournment on his behalf. Mr. R. Islam, learned counsel for the petitioner, submits that the matter, there's an urgency in the matter and therefore matter should be taken up positively on next date of listing. List accordingly. 4th.
Matter.
Oblige, Lordship.
May I please, Lordship? I'm saying some maybe possible for timing, Lordship.
Not timing today. What is this? The matter.
Matter relating to the lordship,
Appointment of a secretary of a cooperative society. He has been
I see.
suspended.
Ah,
The
who's appearing?
G Uddin lordship.
Uddin, but why timing in the morning?
He will come shortly. May pass for timing lordship.
No timing. He goes to another date. It is submitted that the Aging Council, Mr. is
He
not
will come
available in
shortly
court.
lordship. If possible, maybe pass for timing lordship.
No, no,
Matter
no,
lordship,
no timing.
pending is long.
Either you proceed with the matter or we pass it over to another date. No timing. There are matters, hearing matters are there. So in the middle of that, we'll not be able to take up.
Yes.
The matter be listed next week.
Short date lordship.
Next week,
Date may be fixed.
we don't know whatever date the registry will fix, it will come.
Right.
Next.
Oblige.
Yes, Mr. Khan.
May I please? And this matter is relating to non-payment of area salary for certain period of time. That is from 1/6/2019 to 28 to 2022. What happened, Lordship? Prior to this repetition, Lordship, several round of repetition were taken place.
Secondary education,
Lord-
instructions.
Lordship, Lordship, some more time may be given here.
What time, some more time? Why you not paying the area salary?
Lordship, because the proposal was sent to the government, your Lordship. Director of Secondary Education had sent a proposal on 5th of October, your Lordship.
You
So
pursue
that's
it, pursue it.
Lordship, but the government has requested for some time, your Lordship, because,
Give a specific date. This sometime business
Lordship,
is
Yeah.
not working out. You have to ask for a specific date.
But that is already, Lordship, on the last date, Lordship, same prayer was made. Lordship, the proposal that was submitted on 22 to 3/2022.
Was there any affidavit filed?
Yes, started one affidavit filed by the director, Lordship.
Where is it?
Not at the a big affidavit, Lordship, only. Big affidavit.
Secretary, Government School Education was directed to file an affidavit. Where is it?
No affidavit was filed by
only
the
director has filed. your
Director
Lordship.
has
We
filed.
have not
Kindly
filed.
come to the last order,
Right.
earlier order 21/9/2023,
Lordship.
para 11. Do you have a copy? Share it with her. Do you have
Lordship,
a copy of the order?
Lordship, I have.
He's appearing in a.
There is a direction at para 11 for
Lordship,
the Secretary, Government of Assam, Department of School Education to file an affidavit on or before 13/10.
Okay.
What has happened?
Lordship, the director has given the instruction, but the government is still, it's awaited, your Lordship, the instruction.
What government has? You're appearing on whose behalf?
Lordship, we are appearing for director and for the Secretary of
Then?
School Education.
The Secretary was directed.
Lordship.
Why has he not complied with this order?
Lordship, sometime,
Take down.
2 weeks maybe.
By earlier order dated 21/9/2023, this court had directed the Secretary, Government of Assam, Department of School Education, as well as the Director of Secondary Education to file an affidavit, additional affidavit, to apprise the court as to whether the petitioner is entitled for area salary as claimed by him to be payable from public exchequer. So, this affidavit was directed to be filed on or before 13/10/2023. Matter was posted on 7/11. Stop. On 7/11, further time was enlarged to the respondents to file their affidavit. Today, when the matter is called up, Senate Standing Council, Secondary Education renews her prayer for further time. such affidavit as on date has not been filed.
Lordship, director has
Such
filed.
conduct of the respondents is deprecated. Since there is already an order on 21/9/2023, the respondents, Director Secondary Education and Secretary Department of School Education, will positively file the affidavit as directed by the next date fixed, which is 11 December,
Lordship.
failing which consequential orders may be passed by this court. By 11, give a shorter date, 8th of December. File on 8th of December. Please apprise your clients.
Lordship.
They are taking orders too lightly.
Lordship.
We are putting your government councils to notice that these kind of orders, if it is passed, either you comply with it or you file your proper applications seeking extension.
Obliged. Lord.
Or
Today, the matters are fixed for consideration of our interim pair with regard to release of our current salary. Because for the last 1.5 years, Lordship, we are without any salary and we are serving.
where is your counterpart? Yes, secondary education, who's appearing?
Lordship, our services have not been disturbed. Only Lordship, our salary have been stopped from May and July 2022.
Lordship, yesterday we had filed the affidavit, Your Lordship.
Lordship,
Have you received a
we
copy?
have not served a copy, Lordship.
Lordship will give it.
Huh?
Not serving a
Lordship
copy.
will-
How can you file an affidavit without
Without
serving a
serving a
copy?
Lordship, because yesterday it was filed, but then we have to put it online also, Your Lordship. So today, right now, it will be given you.
No, but the filing rules
Lordship,
require prior service of copies before you file it.
Lordship.
So
Lordship, I have copies, Lordship.
you have
I'm
copies,
giving
but your statement that it is filed is perhaps not correct.
Lordship.
Lordship may kindly consider our Lordship.
We don't know. They have stated they have filed some affidavit. What is your prayer in the writ petition?
Lordship, we are after 3 rounds of verification, Lordship, our services were provincialized. We have served 13 to 14 years. The only thing is that, Lordship, the subject concurrence was received after 1/1/2006. 1/1/2006. And Lordship, in fact, Lordship, there was the amendment proposal long back, Lordship. Lordship, may kindly see page 24. Page 24, Lordship.
Yes, please.
In the Lordship, last column, Lordship, to be clarified, in case of junior college which have established obtained permission concurrence from the concerned authorities on or before 1/1/2006, but subsequently obtained government concurrence on subjects from the state later on, the subjects be considered along with the respective institutions for coming into the force of this act. So it is in the spirit of this Lordship, amendment proposal, Lordship, our services have been provincialized. And that too after 3 rounds of verification by both at the district level and the state level. Now suddenly, Lordship, DSC Assam has stopped our salary from the month of May and July. And Lordship, without any so force and anything, without any prior notice.
You are all regularized.
Yes, Lordship, and Lordship, it was they have not been obtained prior approval from the finance department before stopping our salary.
No, your what salary? Current salary.
Current salary, and we have not received salary from May 2020. Our services have
Yes,
not
madam.
been
What is
disturbed.
your stand? What is your stand, madam?
Lordship, the stand that we had given is that they were all provincialized under the 2017 Act, Your Lordship. And with a condition that if any of the information is found incorrect or false at a later stage, the order of provincialization will stand cancelled immediately, Your Lordship.
But
And
does it include stoppage of salary?
Lordship,
You have not cancelled their appointment.
Lordship.
Then Who is supposed to give the instructions here?
Lordship,
Who is supposed to give the instructions here?
Lordship, we had also served a copy.
You
to
release
them.
the current salary.
Copy has been served, Your Lordship. Yesterday we had given, has been filed.
It has been submitted to clerk.
It is submitted that by MSD Mushari, that Learned Standing Council, that an affidavit has been filed. When, today or yesterday?
Yesterday, Your Lordship.
Yesterday. Copies of which have been served on the counsel for the petitioner accordingly. However, this copy is not available in the case record registry to verify and connect the affidavit stated to have been filed and list the matter again next week. It is served, then you don't have a copy.
Lordship,
It has been
it was
given.
served
to-
in the office of the clerk. He has not been informed.
Are we required to wait for concurrence from your clerk? All right, next week.
Obliged, Your Lordship.
Lordship, may kindly fix the date.
You receive the affidavit, you see, you may like to file a rejoinder. So what is the point in fixing date after date? Once you are agreed that you want to hear the matter, we'll fix a date. Yes.
Matter may be possible for timing. My senior is on next.
Instead of timing, my lord, may any other form lordship today,
Sir, nathake. Sir, 1 month ago Singapore যাব।
your lordship, at two I will try lordship. He partnered matters is continuously lordship.
Have it on some other date.
No, Lordship, today. After 5 minutes. Only 5
Today
minutes.
and your senior is not there, you are not willing to argue. What is this?
Lordship,
You argue the matter.
5 minutes. Lordship.
What are we supposed to do 5 minutes?
Next matter, Lordship.
Yes, all right, time being.
Obliged, Lordship.
But the release of pension, my lord, my friend possibly my lord sent letter to the AG, my lord.
We have submitted the proposal to the AG Lord before the AG.
Better we have to wait, my lord.
Yes, AG. It is submitted by the Learned Counsel for the petitioner as well as Mr. H. Das, counsel for the petitioner, as well as Mr. Upadhyay,
N.
Learned
Upadhyay, Lord.
N. Upadhyay for irrigation.
Lord.
That the pension papers have been furnished by the department and forwarded to the Accountant General's office, MS so-and-so, Learned Counsel. Your name, please?
Lala.
A. Lala, Learned Counsel, appearing for the Accountant General, seeks time to obtain the required instructions in the matter. She prays for 2 weeks' time. Matter be deferred for 2 weeks.
That will be
Copy of the communication by which the papers of the petitioner have been furnished to the Accountant General's office by the Department of Irrigation is placed before the court and is kept in the case record.
All right.
Released after 2 weeks.
All right.
Where is Mr. Chamaria? Yes, Mr. Bora.
Lordship, otherwise, we have filed the affidavit. Things are otherwise complete. But they have not yet filed any rejoinder to our affidavit in
right.
opposition.
Matter is passed over for the day since the Learned Counsel for the petitioner is not available. Mr. D. Bora appears for the state of Assam. Passed over. Yes.
Lordship, before starting this lordship, I mean, in this case, lordship, for higher education technical department, P. Upamanu is appearing, lordship. Today he is unwell, lordship. I contacted him.
What is the matter about?
There
What is the issue about?
There is some instruction from the higher education technical department regarding civil engineering or is equivalent to or not. He says that the instruction not yet received.
So what is the issue here?
Lordship, this is a serious matter where all the writ petitions are similarly situated. Two contentions are there regarding that one particular writ petition, set of writ petitions belongs to Diploma in Construction Technology and one belongs to Diploma in Civil Engineering and Planning. The contentions that have been raised in all these.
They are not recognized by AICT.
No, both are, they are recognized.
That is not right. The
Pursuant
issue here, Lordship, in 2019, Department published an advertisement for recruitment of junior engineer. And the education qualification required, as mentioned in the advertisement, diploma in civil engineering. Now, Lordship, they are diploma in civil engineering and planning and diploma in construction technology. Issue is whether they may be allowed to participate in the recruitment process or not. Right.
Where is the advertisement here?
Lordship will file page number.
Page 63 of petition number 5355.
No, you tell us in 2994 who's appearing.
2994.
Sorry, 2064. 2064, who's appearing?
Declaration of Mopidul.
This is a different matter, my lord. They are for the declaration of result. Yes.
Huh?
They are for the declaration of result. Because
They are clubbed together.
Yes, clubbed together, my lord.
Why?
Because they have come a bit late. Because of the fact that
The
since
successful
interim orders are there, therefore the results have been stayed. Now they have come with Mopidul Islam and the others, they have come for declaration of the result. Now these all the petitions are clubbed together. In the main contentions on the previous date was that the higher education department had to give instructions to the APS regarding and the department regarding whether they are accepting construction technology also as equivalent to diploma in civil engineering. Already one part of the contention has been settled through a corresponding letter from the government stating that diploma in civil engineering and planning is equivalent to diploma in civil engineering. But our contention, that is in writ petition 5400 and 5430, that is Nilotpal Das and others and Rupam Kolita and others, our contention is that we are diploma in construction technology. Now, our contention has not been properly addressed, my lord. And that was the reason, like on last occasion, we have again recorded it before the Honorable Court, and the same has to be now taken from the part of the government. And they have to come out with a proper instruction. And that instruction has to be in writing, my lord.
The advertisement is dated
2019 advertisement.
My lord has WPC 5495. I can that is
19 November 2019.
Yes,
My lord, 2019 advertisement, my lord.
So from the advertisement, show us what is the education
My lord, may
qualification.
kindly come to page, second page of the advertisement, my lord. Point number 5, my lord, educational qualification. A candidate must have passed 3 years diploma course in civil engineering from an institution recognized by the government. Now, my lord, they are civil engineering and planning or some other course, which is not same as civil engineering, my lord.
Who will decide that?
My lord?
Who decides that?
AICT, my lord.
Exactly. They are the candidates who appear for the interview. First of all, I don't understand how they have locus to argue in this case when a relief is against the government, my lord.
Their relief is against us also, my lord.
How, my lord, if they don't qualify for the interview, how can they, my lord, have the locus?
My lord, may I make my submissions, my lord? Similar matters were before this court, my lord, earlier 3 occasions, my lord, where the candidates of civil engineering and planning also came before this court for a declaration that the civil engineering and civil engineering planning are both same. Then this court passed order. This court have asked that committee be formed, and that committee decide whether these are same or not. And if the committee decides in their favor that it is same, they will be allowed for further process of the interview. And if not, then they will not be allowed. Then the committee decided, my lord, that it is not same. Committee have taken into consideration
Committee comprising of what members?
My lord, may kindly take the affidavit filed by the APSC.
So just tell us. Why do you have to take us to the pleadings and pages? Just tell us. We are asking you a
My
question.
lord, the committee was comprised of, my lord,
Technicals of the polytechnic
Higher
institutions, my lord.
Secretary Higher Education Department, Secretary APSC, Controller of Examination APSC,
It is for the AICT to decide.
Yes,
Yes,
my lord, they
my-
are the candidates.
My lord, the
It
submission-
it is
don't
the
know that
AICT
local they have
who
to
gives
argue.
recognition to or
My
maintains
lord,
the.
now this decision, my lord,
Huh.
the committee report is not under challenge, my lord.
My lord, they are the candidates. My humble
Committee
submission is
report or
what locals they have
not,
to argue.
In one of the
Locus,
matters-
who
what is the
decides?
locus?
No, who decides? Today, supposing there is a question about a degree or a diploma or a distance education with regard to law, who decides? The Bar Council.
My lord.
Can it be decided by a committee of high-ranking officials?
Man.
It's the Bar Council who's given the responsibility. Similarly, for technical education, it is AICT.
My lord.
Now, my lord, if we come to the advertisement, my lord,
Hmm.
it is very clear, my lord.
That's
My lord,
right. It says Bachelor of Engineering, bachelor's degree. Huh?
My lord, that is the second advertisement. The person to that, there was an earlier advertisement. That is diploma in civil engineering.
Okay.
My lord, what has happened that, first of all, we are being told that diploma in civil engineering and civil engineering planning was not equivalent. However, later on, for the same kind of advertisement, there was being by the government, it was said that civil engineering and planning would also come under junior engineering civil. My
No,
lord.
but how can the government say that without?
Exactly, my lord. Therefore, they are saying that they will seek instructions, my lord.
Hmm.
Therefore, once the instruction has been got, then
My
we
lord,
can roll
once
upon.
the DT gives us the director of technical education,
What will they give?
they will have to come with an affidavit. They have not yet.
No. What affidavit to what effect?
yes, ma'am.
Can they override the views of the AICT?
No,
Is
yes,
the AICT
yes, that is the
whose
part.
call is final?
Yes, so AICT has already given the clarification. Now.
Oh.
So that is our only contention. And these matters have been dragging only because of coming into that point. Already stands have been taken on that.
Yes. Everyone is blaming the higher education. Where is the higher education council?
So far as equivalency of all the courses are concerned, lot people consider one thing in the rule it has been mentioned in diploma in civil engineering. No equivalent word is used here. In the advertisement, it has been mentioned as diploma in civil engineering. Initially, we took view from the AICTE notice. They say diploma in civil engineering and diploma in civil engineering and planning are equivalent. Equivalency is concerned not that is okay. Diploma in homeopathy, diploma in Ayurvedic, equivalent. Skills are different. Our argument will be on that line of it. Diploma in
So
civil
how will a read court decide on this?
that is the issue now.
Then you go and
It will be decided by the
No.
law by the court not.
no, correct. So the
My-
court
my-
would rely on a statutory body's view.
No, lot is my submission will be this matter will be decided in terms of the law settled by the Supreme Court whether the required educational qualification as mentioned in the rule can be relaxed. or
If it is already decided by Supreme Court, then why are we wasting time here? The law stands covered. You place the judgment.
Secondly, Lordship, on last date, Lordship, I filed one affidavit.
Hmm.
Subsequently, I received another instruction, Lordship.
Hmm.
In the first instruction, an instruction was issued to the APSC.
You are representing whom?
PWD,
PWD.
my department.
So you have no control over this. You want only engineers.
Yes.
The recruitment is done by the APSC.
Lordship, they will done as per our requirement.
No, correct. Your requirement is not a diploma or a degree or in planning or education.
Yes.
Your requirement is civil engineering.
Yes.
Right? So you have given the requisition, APSC will conduct the engineering. Now the dispute is whether diploma in XY is equivalent to diploma in civil engineering. That is a decision which PWD can't take up. It is a decision APSC can't take up. It can only be given by the AICT.
That is one part. Lordship.
Ah.
My part will be whether the condition mentioned.
Once the AICT says that it is equivalent, can
Equivalent is
the
okay,
department say that no, we will not refuse to accept?
Lordship, even if the AICT says that it is equivalent in the year 2022,
Hmm.
whereas the advertisement was of the 19 law. Two contentions will be there, whether the requirement mentioned in the rule and in the advertisement can be diluted or relaxed in later part.
But AICT will not take responsibility for your competence. Tomorrow, if the roads and bridges get washed away or broken because you have a diploma, who will be responsible?
My lord, the notification from the AICT came in 2017 itself regarding the relevancy of the appropriate branches of civil engineering. Then in 2022, there has
All
been
right.
an addenda.
Where
which
is
says
the
that various job
where is the
situations-
elusive Standing Council for Higher Education?
On last day, one question arose, Lordship.
How many standing councils for higher education are there?
Lordship, the concerned one is today not
No,
there.
concerned is okay, but in a matter of this magnitude, one person not there, is there no other standing council available?
Lordship,
Lordship, D. Upamanyu is appearing, Lordship. Highly said within.
No, D. Upamanyu is
Lordship,
appearing, but he is a
Lordship,
standing counsel.
But he said that the instruction has not received yet, Lordship. The particular regarding this.
You said in the just a while ago that some instructions are there.
That's true,
So the
Lordship.
some instruction is that there is no instruction,
Yes, Lordship.
which is why he has disappeared.
I just come and I contact him the other day with
All right.
Lordship.
You have filed, who has filed some application?
My lord, we have filed.
Let it be connected to the case record. We'll take it up.
Lordship, Lordship, in the last occasion, it was listed for further hearing. It was considerably heard at length. But to peruse the order dated 14/11/2023, para 10.
Then you point out before the court, before the registry. It is pointed out by Mr. D.P. Bora, learned counsel for the petitioner, that the matter was extensively heard before a coordinate bench, which is evident from the order dated 14/11/2023. Accordingly, the matter stands, the registry is directed to place the matter before the coordinate bench. Place the matter before the Chief Justice acting for appropriate orders on the administrative side. Deeply. Why?
That is not a regular bench. Yes, to some extent that bench heard the
There is an order.
but yet instruction is not clear. Instruction is yet to come, Lord.
No, I didn't get you. There is an order saying that for further hearing.
Lordship, my duty was to point out, brought to the notice of.
That's all right.
Delay, my lord, it is not a regular bench. It is not a regular bench.
You go and urge before the registry. Why are you making all this? I'm not supposed to decide on the roster. There's a specific order saying that it is heard in extenso. So therefore, the matter to be placed before the Honorable Chief Justice acting on the administrative side by the registry.
Obligement.
May it please, Lordships.
Yes.
Lordships, may kindly produce the order dated 29/2023. The matter before your Lordships is with regard to the payment of salary due to the petitioner's husband, your Lordships. During his service, he acquired a disability. He met with an accident and he acquired a disability, your Lordships. And in fact, he has lost his cognitive and physical abilities and he's basically bedridden. Lordships, in terms of these Rights of Persons with Disabilities Act, Section 24, the government is required to create a supernumerary post and accommodate him in that particular post and continue to pay his salaries. Lordships, on an earlier, this is the second round of litigation before your Lordships. In the first round of litigation, there's already an order by this honorable court saying that you verify his disability, and if it is found that his disability is correct, then you pay him the dues. When they did not comply, they have ascertained my disability as 100%. And despite that, they did not pay the salaries or the dues to acknowledgeable to him.
You are a person with benchmark disability.
Yes, he has acquired the disability. He was
Subsequently,
but during his service period, Your Lordships. And
and he was unable to attend to his normal
Lordships,
course
he's
of
lost
duty.
his cognitive and his physical abilities. He's 100% disability impaired. He's complete, even his cognitive abilities, Your Lordships. He cannot. He's unable to understand. He has the age of a 3-year-old child now, Your Lordships. That is the difficulty. So several issues have been placed before this honorable court on several occasions by the respondents, saying that
He is not superannuated as on date.
they have not created the supernumerary post.
No. What is his age? What is his age?
His age is about 55 years old right now. His date of retirement is 28th of February 2028. So he has another 5 years of service before he retires. Now, Your Lordships, when we had filed this petition, the wife has filed this petition seeking the salary component, Your Lordships. That itself, because now she's facing a lot of difficulties insofar as her.
Isn't there any disability pension or anything like that?
Lordship, there is a scheme. There is Rule 82 of the Assam Pension Rules talks about disability allowance, but that would perhaps not be taken into consideration, considering the fact that as per the things general proceed and things special follow. Now, the Act of the Rights of Persons with Disabilities has come in 2016. It is a special act which brings into focus special provisions for persons with disabilities. So any law which is in consonance with that particular provision would perhaps not hold the ground. In fact, the central government have themselves in the CCA rules, in the CCS pension rules, Your Lordship, they have already made the relevant changes and have now brought in that change that invalid pension will no longer be required to be given. What will be required to be done is to create a supernumerary post for that particular person in terms of Section 20, Clause 4 of the Rights of Persons with Disabilities. If I may just take Your Lordship to the legal provisions. Now, there was a
And who's the petitioner?
the petitioner is the wife of the employee, Your Lordships. He was an executive engineer working under the PHE department.
জানাই দিয়ক নাই যদি আনিব দিয়ক ডাউনলোড কৰিব দিয়ক নতুন এক নাই মানে আপোনাৰ মতো
It is, Lordships, it is quoted in the page 91. हमारे petition में कहाँ quoted है? Petition में quoted. Lordship, the provision is quoted in the petition as well. I'll just take your Lordship.
My lords, everything is admitted. We are just under process. Lordship will see, last occasion I had produced a communication whereby his proposal creation for superannuation post is being moved. We are not disputing anything.
Page 29, Your Lordship, the provision of the law. Lordship,
you
the
tell
only
us what
thing that-
which section?
Section 20, Clause 4, Your Lordship. Subsection 4. Page 29, it is quoted, Your Lordship. Paragraph 38.
Sub 4.
Yes, Your Lordship.
Kindly
No
read.
government establishment shall dispense with or reduce in rank an employee who acquires a disability during his or her service, provided that if an employee after acquiring disability is not suitable for the post he was holding, he shall be shifted to some other post with the same pay scale and service benefits. Now, the second proviso, Lordship, which is important in our case,
Yes.
provided further that if it is not possible to adjust the employee against any post, he may be kept on a supernumerary post until a suitable post is available or he attains the age of superannuation, whichever is earlier. So in the instant case, the employee concerned is not able to come back to his duties, Lordship. He will not be able to perform any of his duties. Now, there was a order passed by this, even in this writ petition, Your Lordship, on 29/2023. A voluminous order was passed by this honorable court to release at least the part payment of his salary, Your Lordship. They can continue with the process of creating the supernumerary post, but at least in the meanwhile, they could release a little amount of my salaries, Your Lordship, which has been pending. More than 35 lakhs is due as of date, Your Lordship.
Yes.
My little Perus,
This is the letter which we have written to the.
this is my little in context to what had happened. Unfortunately, my lord, this person has exhausted all his extraordinary leave benefits and pay benefits. Lordship will kindly peruse the order in the 7/11, wherein my lord, I had produced a communication whereby my lord, the AG office was moved. AG has raised some queries. We are in the process of answering those queries and letters will be submitted by tomorrow or this evening.
When was the last time he received his salary?
Lordships, in the interim, at one point of time, they had paid me some amount of money, which was approximately 10 lakhs, Lordship. I have made that statement at paragraph
When?
Page 12.
When was it made?
Lordships, April, Lordships, intermittently, Lordships. It is March 2019 till date. They were making some intermittent payments to me, which was approximately 10,21,326. I have made that statement at page 12, Your Lordship, paragraph 11.
What has this got to do with it? Half pay leave and all that?
No, my lord. This person, my lord, unfortunately exhausted everything what is admissible to him. So a leave admissibility report has to be prepared, my lord. So we have written to the AG. AG has raised some queries, and this is the communication we received back from the AG. My learned senior has placed, my lord. So in the process of answering those queries, and anything which is due will be released, my lord. Nothing stopping. This process, my lord, lordship knows, my lord, how the papers move.
More than 1 year,
we are
Your
not
Lordships.
disputing anything.
The first writ petition was filed sometime in the month of October 2022, Your Lordships. Till date, I am on the second round of litigation. I filed a contempt. And the order passed by this honorable court was also of September 2023.
Lordship will see that 1311, there is a communication. Earned leave, half pay leave.
So how long does it take to give the
Well,
administrative?
this is under process. That's why I'm asking, Lordship, I'm praying the matter will be listed next week. Because AG has forwarded and we are in the course of replying. This is a letter of 1311. Today we are on 22.
And why are you raising all these queries?
The AG is raising, my lords, because this person, as I have stated earlier, my lord, this person has
Why are you
exhausted
raising
everything.
all these queries in the face of an order of this court, in the face of the provisions of the statute?
No. My lord, statute speaks of the creation of a post. That part is gone. We are on a process, my lord. Statute says of a post.
No, how is it gone? Have you created a post?
My lord, it's under process, my lord.
Then?
My lord, in earlier round, my lord, there was a department called Assam Administrative Reforms, my lord. We had sought the advice. They said that this person may be granted invalid pension, which was found incorrect. We sent back the proposal, my lords, and we processed papers for creation of a supernumerary post to the personal department. It's under process. That statute part is gone. Now, my lord, as regards his administrability and his money, what is his due, this person, my lord, has exhausted everything which is due to him. So extraordinary steps have been taken to ensure that he gets what is his minimum. His due is being granted, my lords, but it's under process.
The last order,
711 lordship will see.
last order has recorded that there's nothing in the your note sheets which reflect that you are processing his case for
Or
creation
lordship
of a
proceeding, which order
supernumerary
may I know,
post.
my lords? Order dated.
Order dated is 2009,
My lordship will see 711, my lords. 71123.
711.
711. 711 makes it abundantly clear, my lord, what's going on.
And the accountant general, my learned friend, was supposed to apprise this court as to what has happened.
No, we have asked for admissibility report.
Why have you asked for it?
Leave admissibility report, because without leave admissibility report, we cannot finalize the
Finalize what?
claim of the petitioner.
Uh-huh.
Claim of the petitioner.
What is his claim? Only salary? You're not asking for pension.
Earned leave as on 24.
He has exhausted his earned leave.
Lordships, a supernumerary post does not require anything.
That
It
post
is-
is in
it is
the process of
My
creation, my
post
lord.
is already there. My salary was already there with the government. And in 1961, there is an OM. I have not placed it before this court because it would again create trouble for
So
my
why are you asking all
learned
these
friend.
questions? He's not asking, this is not a case for pension.
Earned leave as on 24/6/2019.
How does it matter?
Area salary no hoy Area salary ki report legi.
It's a arrear salary note, because unless we do not give the government do not fund it, the leave admissibility.
And why are you not paying the current salary?
My lord, he has exhausted everything, so it's on the
What
process.
is the
So,
meaning of exhausted everything?
my lord, if government official has, my lord, some, my lord, a quota of earned leave, a quota of, my lord, his half pay leave, my lord, this person, unfortunately,
Have you
my
passed
lord,
an order saying that in view of his exhaustion of
this order is
leave?
very clear.
Which order?
My lord, this communications I have placed, numerous communications have been placed, my
They
lord.
have not given me a copy of these communications.
We are in the process, we are not disputing anything here, we are not disputing.
You're not
we have
disputing,
sympathy
but
for
you're
the
not
petitioner, my
releasing
lords.
how will the man survive?
We understand that issue, my lord, but this has to go through a process, unfortunately, fortunately, my lord.
No, your processes are, you are not clear what you want to do. That is the whole
No, no,
problem.
we are.
You are not
superintendent-
accepting the fact that you are not clear what you want to do. If you are clear what you want to do as per the procedure, do it.
We are
But you are
doing
not
that.
clear. You are asking,
We
you
are
are
very
sending
clear,
papers
Manoj.
for
We are
this department, that department, asking for clarification.
We are very clear, my lord.
Then-
Supernumerary post is in the process of, my lord, being created now. My lordship will, this term is very clear, supernumerary
All
post, my
right,
lord.
you give us the instructions, we'll have it on
So that's why I'm asking, my lord. We are also
on
under pressure, my lord.
29th November, you give us what is the status of your creation of supernumerary post.
Very well, my lord, 29. We are not disputing, lordship will not get us, get.
You can't dispute.
We are not
I
disputing
appreciate
anything.
your lordship, but
No,
the
no,
fact that
There is also a
you
process.
can't dispute.
We are
That's
not
the
disputing,
mandate
my
of the
lord.
statute.
But problem is, statute part is gone, my lord. That we are accepting. We will
Ah,
create a supernumerary post.
But
As
you're not
regards this-
implementing it.
My lord,
It's not being created as on
it's-
date.
in,
the verge
I
of
had filed
creation.
this petition in April, your lordship, this second round of litigation.
Yes, and AG?
If the admissibility report is submitted to us, we will go ahead with the
He has already made a statement that there is no leave left, exhausted.
So for our records, which concern lottery, 210 days earned leave and
Good.
409 days.
Naturally, lordships have been.
He'll
in one
exhaust it because it's not
Naturally.
attended the duty.
It has already gone. I'm not disputing that.
Is it not evident from the documents?
So, my lord, what has happened?
How
This
much
will-
time it
this-
take to write one sentence that I have exhausted my leave? That
No.
is all that is
My
required
lord,
to be
see,
done.
my lord, there has to be a calculation. A chart has to be prepared. Then it will have consequences on his pension benefits. Thing has to be deducted and adjusted.
He's still got 5-6 years to retire. You take
Exactly.
5-6
Till
years to prepare that.
They are required to pay me the
You
entire salary.
you
That is
take
something you don't understand.
you take a good 4 years to prepare the chart. We have no difficulty on that. But release him some money. Current or
Already
arrear.
released, my lord. It is also admitted. Whatever we could, we have released. Now we call in the AG's court. We'll push it through, my lord. Lord, people give us some time. We are not disputing anything. We are not here.
Yes, AG.
We are not here to obstruct anything.
What have you received? What papers have been sent to you? What papers have you received from the department in respect of the petitioner? You are asking a question. The office did not receive any information regarding resumption of duties.
Yes.
He did not resume duties. Is it not clear from the pleadings, from the orders of the court? Therefore, he was placed under suspension and his leave account could not be updated. What is the meaning of this?
The suspension was revoked also, Your Lordship, a long time back, 2020 itself.
You can't just throw a piece of communication for the sake of delaying the matter.
No, we are not delaying.
Who is delaying?
We have written this letter on 13/11.
I know you have written, I know you are capable of writing letters. We are asking you whether it is necessary to ask this irrelevant question. You show us from a provision of your provisions. Huh?
On 29th, I clarify.
Yes, list the matter again on 29th, by which date the learned standing councils will apprise the court. The process of creation, the status of the process of creation of supernumerary posts as mandated under the so-and-so act, as well as the process for release of area salary. Stop. Any leave report, status of the petitioner's employability, etc., that may be required. If required, may be communicated by the what department is it? Public Health.
PHE.
Public Health Department to the Accountant General before the next date fixed. List accordingly.
Deeply obliged.
Obliged.
Yes, Mr. Solia.
This is a case where the petitioner has been claiming his pension from the Tezpur University. for the
Pension,
last
pension.
16 years.
Yes.
He retired on Scheme 7. And till date, he has not been paid.
You are
the money.
representing?
Lordship, takeover is on legs at port 6, Lordship. One Partha matter is going on there.
Where? 6. Kiman number. They are out. I do not know why they are avoiding the matter from hearing.
No, he was here when you were not there. When the matter
Also,
was called up
not
first.
there. I stuck in the road, Milord. I was on the way. On the other, just your Lordship will see the facts, Milord. They had been
His lien in Tezpur was exhausted.
Then he resigned from the post. Milord.
Post.
And the moment he resigns from the post, Milord, under the rules, Milord, he is entitled to pension.
Who's representing the university? I mean the
Central Government Council.
Central government.
My lord, Rule 5 says,
He retired from where? Nerist.
no,
Then from Tezpur.
I have resigned my service from Tezpur University, and immediately thereafter I have stated that I will take pension from this post because
From which post?
from the Tezpur University post, because in the NARIS they do not have the pension and gratuity rules. They have CPF rules. So CPF rules cannot provide me pension.
You have resigned, you have tendered your voluntary resignation? No.
Yes, that is called technical resignation.
Technical resignation.
Technical
After your lien is over.
Yes, when I continued to post in NARIS, then I
resigned from Tezpur University, and they have accepted it, my lord. And immediately thereafter, my lord, I stated that your lordship will see DN order is Annexure 6, my lord, page 24. There it states, my lord, is granted extraordinary leave from Iman who serve in NERIS Technology Owners of Research as registered hereby released finally from the service at Tezpur University on submission of technical resignation. So technical resignation is also resignation, my lord, under the provisions of FR 22. The benefit of counting the past service at Tezpur University for retirement benefit is admissible to the petitioner. They have categorically stated that. And I have also informed the university after I left the university, my lord, when I joined at page 27 by my letter, that with reference to the above my previous service, I would like to inform you that NERIS does not have pension term at page 27, Annexure 9. Does not have pension term gratuity scheme and have CPF term gratuity scheme as such under transfer of retirement benefits rules. I would like to opt pension term gratuity from Tezpur University in full and start service at NERIS afresh. So that is clear, my lord. There do not have the pension rules. So I stated from this end, my lord, I will end my service on resignation. I will take pension from here and I will start afresh under the CPF rule. I don't see any reasons, my lord, why on the basis of this letter also and on the basis of their resignation acceptance letter, I am not granted pension. They fixed everything. What I get, because for the last, before joining, I was for 6 years in the Anbad School of Mines. That is also central organization.
Okay, when is he available?
At 2 million, because I will be away for some time. And man is without pension, or if your lordship.
At 2?
My lord.
Inform me. At 2 o'clock.
Lovely.
May I please, your lordship, kindly peruse the last order, my lord, para 20, lordship. As per the order, lordship, we have with the authority, lordship, which effect from the date of application, that is 5/12/2020. Paragraph 20 of that order, my lord.
So who has filed this petition now?
Well, the second wife filed, my lord.
Second wife?
After the date of the first wife.
First wife.
Yes. But it is calculated from the date of application, 3 years before. But she has to.
So?
It was giving some time, my lord.
Huh?
Giving some time, my lord. So
They have already issued
yes,
this.
already issued, my lord. Letter issued. Treasury officer is to release it. Immediately after the date, there is no dispute of claim, my lord.
When did the first wife expire?
Expired, my lord. That is appeared, my lord, in the Annexure 6, page 21, my lord.
Just tell us the date.
Yes, my lord. 8/5/2013.
8/5.
8/5.
Fatima Bibi.
Nasiatun, who is Nasiatun?
This petitioner.
Petitioner.
And first wife was Fatima Bibi. Death certificate page 22.
Heard learned counsel for the parties. By order dated 21/9/2023, the following directions were passed. Extract this order. The matter was fixed today for apprising the court about the up-to-date status of family pension, payment of family pension. Stop. Today, when the matter is called up, the counsel for the accountant general has produced a copy of the communication dated 21/11/2023, issued to the treasury officer, Dhubri, requesting the treasury officer to treat to read the date of commencement of family pension in respect to the petitioner from the date of the application, which is 5/12/2020, instead of 9/5/2013. Stop. The said communication was requested to be treated as a letter of authority. Stop. Para. In view of the present position placed before the court, learned counsels are at item that the grievances of the petitioner has been redressed, and therefore no further cause survives to pursue the writ petition any further. In terms of the above, writ petition stands closed. Interim orders, if any, stands vacated.
My name is requested for respondent 1 and 2.
Mr. N. Upadhyay for respondent 1 and 2. Mr. R. K. Talukdar for
3, my lord.
For 3. Any other?
All
All right.
All right.
Let's vote.
The matter is fixed for delivery of orders.
At 2. At 2. Yes. Yes. We're taking up at 2 p.m. Yes. Item 30. Who's appearing? None appears for the petitioner on call none appeared for the petitioner on 2005-2014 as well as on 2004-2018. Accordingly, the writ petition stands dismissed as for non-prosecution. Mr. N. Dhor, R. Dhor appears for PWD.
No, my lord, social welfare.
Huh?
Social welfare.
Social Welfare Department. Interim order, if any, stands vacated. Pending I is also dismissed, if any.
Same it, my lord.
None appears for the petitioner on call. Matter was last listed on 16/9/2014. The matter pertains to appointment, selection and appointment of Anganwadi workers at the Rangimuri Anganwadi Center in the district of Dhemaji. Stop. This dispute arises in respect of the selection and appointment of the petitioner, the respondent number 4 as Anganwadi worker, pursuant to the advertisement dated 7/9/2009. Stop. From the facts narrated in the petition, it appears that the writ petition may have become infructuous on this date. However, since the matter was last listed on 16/9/2014, purely for the ends of justice, the matter is deferred for the day to be listed next week. Names of the registry may take steps to intimate the councils whose names appear in the cause list. Mr. R. Dhor appears for the respondent. List accordingly. I report with you. Huh? Yes.
This was a matter which was taken up yesterday. Or triple recollect, the impleadment petition was allowed, but in the main case, the order which is reflected, there was a wrong name of the party. Has
Yesterday. Yes. Mr. Nayak,
Lordship.
there appears to be some mistake in the order.
Yes, sir.
So the petitioner was directed to be impleaded as party respondent 9.
Yes.
All right, heard learned counsel for the parties. It is pointed out that by IA number 3192 of 2023, a coordinate bench had allowed the IA by order dated 18/10/2023, whereby who is the respondent 9?
Headmaster of the school. Impleadment of headmaster of Kamal Singh MB school.
The headmaster of so-and-so school. What is that?
Kamal Singh MB school, Kokrajhar.
Kamal Singh MB school, Kokrajhar. Namely, what is his name?
Lordship, name will not be required because.
Okay, headmaster Kamal Singh MB school, Kokrajhar was arrayed as a party respondent number 9. Stop. And the IA was accordingly allowed. Stop. However, in the accompanying writ petition or in the writ petition, WPC, in the present writ petition in which the IA was filed, the order was wrongly recorded as under. You reflect this order at 18/10/2023 order in italics. Stop. Learned counsel for the parties submit that this by oversight, the petitioner was shown to be arrayed as party respondent number 9. Stop. Since there is no, since both the councils agree that this was an inadvertent mistake, the order stands corrected. The principal, the headmaster, Kamal Singh, MB School, Kokrajhar, is arrayed as party respondent number 9 in terms of the order dated 18/10/2023, passed in IA Civil 3192 of 2023. The earlier order dated 18/10/2023 stands corrected to that extent. Petitioner shall file amended course title within a period of 1 week from today. Matter be listed by the registry after the filing of the amended course title. Mr. P. Nayak appears for the respondents. All respondents? BTC.
BTC law.
BTC. All right. Yes.
This is the IA filed by the first wife, madam. My husband was late Mokram Ali Borvia, who died on 20/2/04/23. Now, private respondent.
Pension is received by second wife.
Yes.
You have not received.
No.
So you are filing this IA for?
For payment of pension to me, not to her. And the full pension I have also annexed.
Heard Mr. Remy Mahmood, learned counsel for the petitioner, for the applicant. This IA has been filed by the applicant who claims to be the first wife of late Makram Ali Barbhuia, who was employed as, he was working as what?
He was a teacher.
He was employed as a teacher In which school? Assistant teacher in number 1135 of Suta Lekha Lower Primary School, Hojai. Stop. The late husband retired from, superannuated from service, and subsequently on 2004-2023, the late husband expired. Stop. The opposite party number
Number 9.
number 9, who is the second wife of late Makram Ali Barbhuya, had misrepresented these facts before the competent authority and has been receiving the family pension to the exclusion of the applicant. Stop. Mr. Mahmood submits that this is contrary to the provisions of the Assam Pension Rules 1969.
1246. And also against the decision of the full bench.
And also contrary to the decision of the full bench,
Yes, that is
rendered
as annexed.
by judgment and order dated
Dated 22/12/2022, para 19 and 20.
22/12/2022, rendered in
S14 lots.
Writ Appeal 160 of 2018. Stop. Let accordingly, let notice be issued, returnable 4 weeks. Steps since Mr. Pegu appears for
Lordship, I'm for
you are for state.
yes.
There is no state council. Mr. Talukdar appears for the elementary education.
I'm for respondent number 3, Your Lordship.
Mr. Pegu for respondent 3, director of pension. Mr. Talukdar for education department. Mr. Nayak for respondent 7. And who's for accountant general? Mr. R.K. Talukdar for accountant general. Since the learned standing councils had already entered appearances, notices are waived. However, extra copies be furnished within 1 week from today. Steps be taken on by registered post 80 on respondent number 9 within 1 week from today. Matter be listed after the returnable date.
Lordship,
The question of the prayer for stoppage of the pension to respondent number 9 will be considered upon completion of service.
Lordship.
Admittedly, I am the first person.
You are, but without hearing her, how can the pension be cut off? Or you are permitted to take dusty on respondent 9 also. Yes.
Lordship, twofold. My name be recorded as B. Deuri, and secondly, Your Lordship, we have
B. Deuri,
a short
B.
instruction,
Sorry.
Your Lordship, whereby the Director of Pension has said that nowhere in enclosure 1A, nowhere the name of the petitioner is there. So they had furnished only that.
No, nomination is made in favor of respondent number 9, but that is not the law.
So we will decide on it.
Yes, that may be instruction taken.
The justice service upon respondent number 9.
You write, Mr. B. Deuri, learned government advocate, has placed a communication from the Director of Pension to state that, to submit that the name of the respondent opposite party number 9 has been shown as a nominee for family pension. And accordingly, the pension was released. Copy of the instructions is kept on record in the IA. Matter be listed after completion of the service.
Justice service, well.
Yes, we have recorded.
Yes.
You are permitted to take dusty.
Yes, that way can be.
Date.
Yes, short date. Justice service will get.
What we could. 20th December 20.
Hello.
None appears for the petitioner on call. Anyone for the respondents? What is the status here?
I don't know the status, but I don't have the brief.
You get the brief?
Yes, I'll take.
MS A. Gayon, learned CGC, will apprise the court in respect of the claims made by the petitioner for regularization of the services of the petitioner. Petitioners, several petitioners are there.
The 16 number, 17 numbers.
You are representing whom?
Hello?
Assam Rifles.
Yes.
These people are for employed as what? Regularizing the petitioners in their posts, regularizing the petitioners under the Assam Rifles, in which they were rendering services for a very long time. Stop. None appears for the petitioner. Matter was last shown listed. As per the order sheet, matter was last listed on 5/2/2014. Let the matter be listed again on 5th of December. 5th of December.
Yeah, that is before any other date. Pilot before 5th
Before 5th.
or either 11 or 12 pilot.
11 or 12.
Any date, pilot except 5th and 7th.
All right, 12th. 12 December.
Please the law. My lord, this is a matter where the petitioner before your lordship was an employee of the Animal Husbandry and Veterinary Department, my lord, and he was implicated in the LOC issue. He was convicted. Now, my lord, he was convicted, he served the sentence. Lordship may kindly just take note of the date. He was placed on suspension in the year 1993, 29/12/93. However, suspension was revoked and he resumed his duties on 4/9/01.
Yes.
And he retired from service on 31/5/04. Now, my lord, during that period, he was convicted subsequently after his retirement.
Yes.
He was convicted on 29/12/2006. Then he filed an appeal and ultimately he served the sentence and he was released from jail on 10/9/2010. Now, my lord, after his retirement, he was initially paid with the provisional pension. Now, from 2010, that provisional pension was also stopped. The whole issue comes down to only one thing: whether the pension of a person can be stopped in the manner other than what is provided under Rule 21. Lordship may have a look at Rule 21 of the pension.
Could be CCS.
No, Assam.
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 He was employed as?
He was an employee of, my lord,
Veterinary.
Animal Husbandry Department.
Okay. Yes.
He retired as UTA.
Rule
21.
21.
Says the governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery from a person of the whole or part of any pecuniary loss caused to the government. If in a departmental or judicial proceeding, the pensioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered. Now, my lord, admittedly here, no departmental proceeding was initiated. Though he was placed under suspension, but no DP was initiated and he never faced any departmental proceeding.
It is only the judicial proceeding, that is a criminal case, which depends. So the whole question comes that it is the governor who has the right to stop or withdraw or withhold pension. Now, if that power has to be exercised, it has to be exercised by the governor only. That is why now in their affidavit, they have not stated anything. Lordship may have a look at their affidavit. Page number 5, their first affidavit, they have filed 2 affidavits. The first affidavit, which was sworn on 26/2013, page number 5.
Paragraph?
Well, it is not paragraph. It starts, I'm referring page number 5.
Yes.
The pension has been provided under the pension rules. The pension rules which provided for the grant of pension can also provide for taking it away on justifiable ground. Under Rule 21 of the pension rule, if in a judicial proceeding it was found that the government servant pensioner was I do not know what there was gratuity of grave misconduct, was guilty of great misconduct and discharge of official duty during the period of service, the government can order withholding or withdrawing of pension. Now they have acted upon an advice of the law department. It says the government has the power, but that is not the way, my lord. They have the power has to be exercised by the governor. Now further they are saying, they have put it what the LR has opined. In view of it appears that the petitioner has been found guilty of misappropriation of government money and also causing pecuniary loss to the government. There is no assessment.
You want to say that these matters were never placed before the governor?
Yes.
On what basis?
I do not know. That is why Lordship will see an order was passed on 2/6/2023 by this court, directing them to file an affidavit. This court, my lord, on 2/6 has recorded what is the issue precisely in this case and what instruction they have to place before this honorable court. That is an order by the governor in accordance with Rule 12 of the Executive Business Rule. In response to that order, my lord, they filed one additional affidavit, which your lordship will see. It was filed on 17/7/2023.
Yes.
Lordship may come to page number 36, annexure 1 of that affidavit. This is what one Undersecretary to the Government Veterinary Department write. In inviting reference to, I am directed to state that the provisional pension in respect of C so and so may be withheld and no further provisional pension will be allowed to. Now, my lord, lordship is aware when a person post his retirement is facing a disciplinary proceeding or a criminal proceeding or a judicial proceeding, he is paid with provisional pension, and that provisional pension continues till that either the DP or the judicial proceeding comes to an end. After the judicial proceeding or the DP comes to an end, there is no question of continuation of the provisional pension. Either the full pension will be provided to him or it has to be.
On what basis the LRA has given his views that pursuant to a judicial proceeding it can be taken away? Was there any direction in the order of the special judge?
No. There is no, that the special judge has convicted him and sentenced him to undergo, my lord, 5 years or 6 years, 4 years or 5 years of imprisonment. And he has undergone that. Even if your lordship goes to the opinion of the LR is saying that under Rule 21, the government has the power. There is no doubt of it. Under 21, the government has the power. But the question is, who can exercise that power? And how it is to be exercised?
Where is the executive
Rule 12 says that all orders has to be passed in the name of the governor. And my lord,
No. What is the meaning of name of the government?
that means it has to be processed to the governor, and governor will give an opinion, and then someone in the rank of a secretary.
There will have to be an endorsement.
Yes.
That's fine.
Yes. And my lord, lordship will further see it is not the end of the matter. Even if the governor's power to withhold or withdraw pension will have to be, lordship may further go to Rule 21D. The Assam Service Commission shall be consulted before final orders are passed.
No, was he appointed under public service?
He was an UDA. It applies for all under Rule 21. Rule 21 says how it has to be done. First, my lord, the governor has the power either to withhold or withdraw whole or part and recover for a period. Then if the DP was pending, then he will be deemed to be continuing as an employee. But if no DP was initiated before retirement, then my lord, it can be done with the sanction of the governor. And that too in respect of any allegations not beyond 4 years. Then ultimately, so my lord, 21C, no judicial proceeding if not instituted, we are not on that. Lastly, for the Assam Service Commission, it shall be consulted before final orders are passed. So in matters of any withholding of, my understanding of Rule 21 is, in matters of withholding or withdrawing pension in respect of all employees, the governor has to exercise the power in consultation with the commission. Now, in the affidavits, more particularly, lordship, in the first affidavit, their stand was they have approached or proceeded, but nothing has come out, whether actually the governor has exercised that power. And this man retired on, my lord, he is almost, he retired on 31/5/2004. It is almost 20 years now, my lord. Initially, some provisional pension was provided. Even the gratuity and other retirement dues were also not released to him. The second affidavit, that is the additional affidavit filed by the respondent pursuant to the order of this honorable court, is not in terms of the direction contained in that order, my lord. What was actually sought from the department? Whether under Rule 21 the governor has exercised the power, and is there any order? And lordship is aware, mere passing of an order and keeping it in the record doesn't amount to an order. It has to be communicated, because, my lord, the right of a person will be taken away, and will have a right to appeal against that order also. There is no order. Till date, they could not produce any order.
There are judgments of this court on this issue.
My lord, I could find one judgment which says that under Rule 21, the power of the governor is the governor who only can.
No, the pension rules itself refers to, the comments refer to some judgment. Have you looked into this?
I have one judgment.
There's one judgment
This
reported
is of
in
single bench, my lord. It says 2005 supplementary GLT 2003. It says It is the governor who has the power, nobody else, under Rule 21.
No, that's all right. There are other judgments. That's what I'm saying.
Which says that
We don't know. That is what we want you to go through and apprise us, enlighten us. There's a judgment of 2015.
Can I
There's
have the
another one
citation,
of
my lord?
2006, 2007, 2003. Then there's one 1984,
Regarding Rule 21,
withholding of pension.
withholding of pension.
That's
Yes.
the issue.
Yes.
That is the issue.
And the issue is, the Rule 21 is very clear. It is the governor will have the power. That power has to be exercised by the governor. The governor reserves to himself. My lord, again, it reserves to himself. It is not that he has to do it. It is his discretion. He reserves to himself the right of withholding or withdrawing a pension or any part of it. So, my lord, if a person is convicted, then also, my lord, under this rule, whether the
You
governor,
have this copy.
my lord, I have a different one.
You go through this. There are several judgments which are referred to. Have a look, and then we'll continue with this.
But
Because the first thing is, the rules are very clear. From the comments which I can see, is that it is a description of the powers under Rule 21 in the situations where it is to be applied.
Yeah.
In the case of a grave misconduct or negligence, or in some judicial proceeding finding him
Yes.
guilty, etc.
So, my
perhaps-
submission is, it is not automatic.
That's
Suppose-
right. So that is what we want you to find out in these judgments, because there is a reference of the applicability of Rule 21 in the various situations. There is the judgment of Satyanarayan Prasad Gupta.
Of our High
We'll give you this. You can have a look and find out all the
Fine.
judgment. So you can have, and then we'll continue with the hearing on this.
Lordship will appreciate one thing, whether the additional affidavit of the department is what was directed by the court.
Where is the addition filed on?
Filed on, my lord, 17/7. Lordship has seen the 2/6/2023 order and what they have filed. If the governor under Rule 21 has carried out that exercise, there has to be an order withholding or withdrawing pension of the petitioner. There is no such order.
No. We accept your submissions. What we are saying is that there are judgments of the coordinate benches passed earlier on this aspect. So we request your views on these judgments as to what extent this section 20, Rule 21 has been explored in other cases, whether there is any finding by a coordinate bench earlier in this respect. So that is, it is possible that this area may not have been exercised. This question which you are posing before this court has not been addressed. If it is addressed, then we'll have to examine that.
Yes.
So that is only for that purpose. The additional affidavit,
It was filed on 17/7 because there is subsequently there is also an order whereby personal appearance was ordered.
17/7, yes.
Yes, there is an yes. Now, Lordship will see that their stand is paragraph 3. But they don't have any document to support this. And the deponent begs to submit. There was exercise of power in terms of Rule 21 of the Assam Service Pension Rules 69 by an authority empowered to do so. In exercise of power in terms of Rule 21 of the rules, the Assam government of Assam directed the respondent number 2 to withhold the provisional pension in respect of so-and-so by order later dated 2/23/2010. Now, my lord.
On what basis has he issued that directive?
No, there are two things, my lord. First, whether this letter, Lordship may have a look at that letter.
Whether this letter can be understood to be the power reserved for the governor.
No, first thing, whether this letter specifically says that his provisional pension should be stopped. It is not that his entire pension should be stopped. Because, my lord, under Rule 22, provisional pension is provided till the DP or the judicial proceeding continues. Once the judicial proceeding or the DP comes to an end, the provisional pension has to go. Either the whole pension or no pension. So the order or the letter of the undersecretary is in respect of withholding of provisional pension. Automatic, my lord. After the conviction, he is not entitled to provision pension. Either the full pension or no pension or a part of pension after the exercise of Rule 21. So this letter is not an exercise carried under Rule 21. And even if that exercise was carried, then the order, there has to be a specific order stopping or withdrawing the pension. There is no such order, at least from the record. And they are heavily relying on the opinion of the LR. And the next page, they are referring to one letter quoting the opinion of the LR.
Yes, who's for the veterinary? You're representing whom?
I am preparing for Accountant General.
What do you say?
At this stage, we have no role to play.
Why no role? Yes, veterinary department. Yes. You have no instructions and no brief.
My lord, I have missed the case, lordship, I'm sorry. No, for 1 day only, my lord. Next week on Tuesday.
Yeah, 1 week, 2 week is okay, but it's a dismal performance of standing counsel. I must say that. I'm sorry.
My lord, perhaps in this matter, record has already been called for. They've already given the record also. So far, I remember, my lord, in this matter, if the second copy, in providing with the second copy.
No. You take your time. We are not in a hurry. We will go by your pace. Only question is whether the issues which he has raised can be answered from your submissions, because the council has addressed on the issue of that the requirement under Rule 21 has not been complied with.
Yes, my lord. In this matter, my lord, record has already been called for, my lord. They have submitted the record already. My lord,
You go through the records and tell us what is there in terms of Rule 21. You tell us which date would be convenient.
Tuesday, next Tuesday.
so far, I have perused the record. So I remember under Rule 21, governor has not, no such notification is there that governor has already passed such order under Rule 21. So far, I remember, my lord, as record is not with me now.
Record is perhaps with
Submission.
you in your
Record
chamber.
is in my chamber.
In
In my chamber, lordship. So, my lord, may kindly fix this matter on Tuesday, my lord. I will provide it a record.
Tuesday.
Because, my lord.
All right, Tuesday. Let it be on Tuesday.
Yes, 28, I suppose.
28. But we will request the councils to apprise the court on the earlier judgments which
My
are
lord, I'll
recorded.
take note of the judgment.
We'll give you the court master will give you the judgment. All right, list on 28,
28.
Enabling the standing council veterinary to produce the relevant records and address the court. Mr. S. Chakraborty appears for the petitioner. You have to address whether the governor means the government. Is it
Yes,
necessary to send the file to the governor, or is it competent for the government sufficient for the government to pass necessary orders?
Our presence may be
Yes, of course. Your
for
name?
respondent number 6.
Your name?
D. Rabha for respondent.
D. Rava appears for the Accountant General Respondent number 6.
Yeah, please, your lordship. Can it be taken after some time, lordship? The engaged council R. Muzumdar is on lake.
Some other day. Next week. Yes. Dismissal.
No, my lord.
Then?
My lord, wrong fixation of the, wrong implementation of the ACP and MSP scheme. I think the voters organization.
Yes, yes, please carry on.
My lord, the text also will find from paragraph 15. My lord, my case that my lord, in voters organization, my lord, initially, my lord, the junior engineering cadre, they were, my lord, divided into 3 different sub cadres. And my lord, within those sub cadres, my lord, they were given the, my lord, SCP benefit of SCP scheme. But my lord, in terms of CPC recommendation, they were supposed to be merged into a single cadre, and it should have been given the next hierarchical, my lord, benefit of next hierarchical post of engineer. But that was not given. And my lord,
Yes. What is the stand of the department?
they have admitted that, my lord, in terms of the earlier position, they implemented the SCP scheme, and in terms of 6 CPC recommendation, they implemented the 5th CPC recommendation, but without any area benefit. That has also decided by the Honorable Court that, my lord, they are entitled to the areas also. And the Honorable Single Judge has decided the matter. It was went up to, my lord, the Supreme Court, my lord. That has been affirmed, my lord.
Page number?
My lord, these are, my lord, when discussed, my lord, the case of Chandra Kumar. It has in division bench, my lord, the judgment was honored by your lordship. The single bench order lord will find the 11% at page, my lord, 16. Whereby, my lord, junior in the engineers were held to be entitled to the pay scale of, my lord, 5,000 to 8,000, which took from 1196 along with the area. That was affirmed by your lordship in the and division bench.
It is already covered by an earlier judgment. This issue, you say, is covered by the division bench.
Yes. But the issue is not covered by the entitlement. Entitlement of 5,000 to 8,000 with effect from 1/1/96. That has been decided.
That's what I'm saying.
Yes, my lord.
So you are entitled to that.
Yes, I am entitled to that. But
So that
subsequently, my lord.
entitlement was decided on the basis of an earlier judgment of this court,
Yes, my lord.
which again was affirmed by the Supreme Court. Yes, Mr. Chakraborty.
Go through this decisions. Let me go. Otherwise, Lordship, our stand is whatever benefit we have given.
You go through it and tell us at 2.
Lordship, another day.
Another day, all right. Another day. Do you have a copy, extra copy?
I can take down the citations, Lordship.
Yes, yes. Let the matter be listed again. Again
On next Thursday, my lord. Possible.
next Thursday.
38th.
We'll have it on 5th of December.
Can it be 7th, Lordship? If I have a matter, maybe in Kohima, Lordship.
Then 12th. 12th of December. Yes, Mr. Gogoi.
Lordship,
His pension.
Yes.
why we not? He's not entitled, Lordship. He's not entitled from our institute.
Why?
You will entitle prorata pension, Lordship. It will be sent to the Lordship Nerim. They will disburse it.
No. Why is he not entitled to?
Lordship, he is permanently released from our institute, Tezpur University. Lordship.
So what is pro rata pension?
Prorata pension, he will entitle, Lordship. That part will send it to the Lordship, the institute where he is at job, Lordship.
No. His case is he joined back.
Lord. No. Never.
You
never.
did
Never.
not join back.
Never. Never.
Did you join back?
No.
No, I have resigned.
You resigned.
So under Rule 5 of the rules, my lord,
CCS.
one will be entitled to pension.
Rule 5.
Yes, my lord, Rule 5.
Yes.
Claim to pension or family pension. Any claim to pension or family pension shall be regulated by the provisions of these rules in force at the time when a government servant retires or is retired or is discharged or is allowed to resign from service or dies, as the case may be. When I resign, my lord, I am entitled to pension. I have resigned from that institute. So I am entitled to pension from that institute only. And I have already shown your lordship the letter by which I have stated I will get the pension from your institute, since there is no provision of pension and gratuity in the other institute, and I will.
Yes. Why is he not entitled?
My lord, may kindly come to our file by our affidavit in Annexure 6, Lordship. It's not resigned, it's a technical resignation, Lordship, for that particular post. Page CL number, page 54, in our affidavit, Lordship.
54.
54 of our affidavit, Lordship.
Yes.
Please. The next are R6, Lordship. It's a technical registration from the post of deputy registrar, Lordship. I was released initially for 1 year on so-and-so to join the post of registrar, Northeastern Regional Institute of Science and Technology, Nearest, usually Itanagar,
Later on, further extension was given for 3 months, so and so. Further extension could not be considered, and I was asked to resume back the Tezpur University video letter at so and so within the month of so and so. Director of NERIST has also given his consent by this letter to demand. Considering the above points, I am decided to continue the register of NERIST and to submit my technical resignation.
So
From the substantive post of Deputy Registrar of Tezpur University. As such, it is requested that my technical registration with resignation with effect from so and so should be prepared.
So
And
how is it an exclusion under Rule 5?
Lordship. So it's come under page 59, Lordship. It's a mobility of persons between central government department and autonomous bodies. Counting of service for pension. Lordship.
Yes, what
Page
does it say?
59, Lordship.
Yes.
Page 59 is also, Lordship, in that particular book, Lordship. In page 459, Lordship. Page 459, Lordship. No, sorry, Lordship, it's page 448. 448.
Yes.
448, Lordship. 448, my Lord, may kindly come directly to 450, Lordship.
450.
Autonomous body where the pension scheme is not in operation. The nearest, Lordship, the pension scheme is not there, Lordship. Where
No,
it is
you are reading from 450.
450, Lordship, B.
450?
B, Lordship, B.
B.
B for Bombay, Lordship.
From the book.
Book, Lordship.
450 begins with one para 3.
Probably, Lordship. Then, my Lord, may kindly come to page 59.
Okay.
Probably that Samis pension, Lordship. That book, Lordship. Pension compilation of Samis.
450.
450, Lordship.
Yes, autonomous body.
Lordship, autonomous body where a pension scheme is not in operation. A permanent central government employee born on pensionable establishment or absorption under the such autonomous body will be eligible for pro rata retirement benefits in accordance with the provisions of the Ministry's Finance so and so as amended from time to time. Is covered by this law.
Please read that properly.
Lordship.
Go to
Please
second.
read that.
Second clause is important. Clause 2 is important.
Clause 2.
It will be, in my case, it is clause 2.
I will explain, Lordship.
First read clause 1.
First read, Lordship. A permanent central government employee born on a pensionable establishment on absorption under such autonomous body will be eligible for a retirement benefit in accordance with the provisions of Ministry's Finance Department OM so and so, as amended so and so. He is a permanent employee of the central government institute, that is the Lordship, Tezpur University, Lordship, and he was absorbed in the Lordship NERIST, where
No,
there is
you read this, you read 1 and 2.
Lordship.
Read 1 and 2. Both.
Once again, Lordship. In a quasi-permanent or temporary employee, the terminal gratuity as may be admissible under the rule would
This
be.
is not relevant. I think.
This is not relevant.
Okay,
That's
then come to 2.
2, Lordship, an employee of an autonomous body. He is not an employee of an autonomous body. On permanent absorption under the central government, Lordship, institute. He was a employee of the central government, that is the Tezpur University. He was permanently absorbed in the NERIST, Lordship. So it's applicable B1, Lordship. B2 is applicable, Lordship. When he came from NERIST to, Lordship, Tezpur University, then B2 is applicable, Lordship. He's neither come from NERIST, Lordship, nor a employee from the NERIST.
Where is that OM dated 8th of April, 76?
76, Lordship, probably this book that is not there, Lordship. If Lordship sometime given, I can, Lordship, that OM, I can, Lordship.
What does the OM say, Mr. Cholia? Do you have any access?
It OM.
Employees of Tezpur University are central government employees.
Central government, they are born in the pensionable service, Lordship. They are born in the Originally petitioner in one institute in Rasi Lordship, and he was then Lordship on deputation came to the Tezpur University. Tezpur University he has permanently absorbed. Accordingly, that institute has Lordship referred the pro rata pension benefit to the Tezpur University. Now after Tezpur University, he chose to Lordship as a deputy director of the Neris Lordship, and also given the technical resignation Lordship, and so it's applicable Lordship B1 Lordship. He is from the pensionable service Central Institute to be autonomous body Lordship. He is not from a autonomous body to Lordship central government Lordship. The Lordship 2 is applicable when an employee came from the autonomous body to a central institute Lordship.
If your lordship read the clause 2, it makes it clear, my lord. It says on permanent absorption will have the option to either receive CPF benefits which have accrued to him from the autonomous body or start his service afresh in the government or choose to count service rendered in that body as qualifying service for pension in the government by foregoing employer's share in the contributor provident fund. And here, my learned friend has not shown the order by which he was released from here, as I have already, I think, mentioned page 24 of my petition, where he was released. He is hereby released finally from the service of Tezpur on submission of technical resignation.
No, this number 2 at page 60 is applicable. Oh, the opening lines say that you are an employee.
We have option either to CPF.
Huh?
We have option either to CPF.
No, but it relates to an employee of an autonomous body.
Yes.
You are not an employee of the autonomous body. You are an employee of the central government.
Yes. And for that, my lord, clause beginning page 59, that states, in case of autonomous bodies where pension scheme is in operation, and I am applicable to that only.
59, yes.
My learned friend has referred to page 59. Beginning, that says, in case of autonomous bodies where pension scheme is in operation.
Yes.
I am applicable to that only.
How?
Because I am in the autonomous body.
If that be so,
Tezpur University was an autonomous body.
If that be so, lordship.
No. If it is an autonomous body, then you're how do you claim to be a central government employee?
Because it is under central government. It is funded by the central government.
No. This is not.
It is funded by the central government, Milord. So, although it is autonomous body, it is under the central government. Totally, wholly funded.
You are, kindly come to the first paragraph.
My lord. Where a central government employee, I was a central government all along. Then I came to.
No, first paragraph, the opening paragraph of the office memorandum. As per existing orders.
Service rendered by the central government does not count for.
Service rendered outside central government.
Does not count for pension in central government except in the case of scientific employees, autonomous bodies financed by, it says, autonomous bodies financed by central government.
No. What is your status? Are you an employee of an autonomous body or you're a central government employee?
I was a central government employee.
How?
because I was in the, originally I have stated, I was for 8 years.
So your service born into the central government cadre,
Yes.
central government, arises out of your services under the Tezpur University,
No.
Central
previously-
University.
Previously, I was in the AG UP.
Okay.
Then for next, I went to Geological Survey of India, voter central government. Then I came to Dhanbad Institute of Mind. That is also central government. From there, I came to Tezpur University. So since Tezpur University is a central organization, Milan, I am permitted under this rule. And for that, Milord, clause A is applicable in my case. In case of autonomous bodies where pension scheme is operation, is in operation.
No, then you come to para number 2. You have to read para 2 also.
A member of central autonomous statutory bodies have also inducted pension schemes for their employees on line with pension schemes available to the central government employees. It has therefore been urged by such autonomous bodies that the services rendered by their employees under the central government or other autonomous bodies before joining the autonomous body may be allowed to be counted. That way, my services counted.
Counted where?
Counted at last in the Tezpur University. Allowed to be counted because previously I was in the central government department. Then I came to Tezpur University. That is autonomous body under the central government. Before joining the may be allowed to be counted for combination in which service in the autonomous
How many
body.
years did you spend in the central government, Tezpur University?
My lord,
How many years of service did you have in
from
Tezpur?
2000 to 2006, my lord.
4 years.
6 years.
2002 to
2000 to 2006.
okay, 6 years.
2007.
7 years.
Almost 7 years.
Now,
Because-
Mr. Gogoi,
Lordship.
assuming he did not go on deputation, he would have retired as an employee of the Tezpur University. Would he have been eligible for pension?
Lordship, then he is from our institute. Lordship.
No, would he be eligible? Yes or no?
He is eligible because he
But
is
he has put in only 6 years of service. What is
years
your
of service.
qualifying?
6 years of service, but he is a member of a IMS Dhanbad Lordship. It's a equivalent institute to the Tezpur
So you are
University.
taking his past services.
Lordship.
You are
that-
taking his past
that-
services.
That service was already protected.
Right.
That part no controversy.
But
Only issue is here.
now, once you accept him to be in the cadre of
Lordship.
central government,
Lordship.
born out of central government,
Lordship.
employee of central
Lordship.
university,
Lordship.
the moment he submits his resignation,
Lordship.
he'd be entitled to pension.
He is not resignation. Technical resignation to Lordship accommodated in the nearest Lordship, the autonomous body Lordship.
Whatever technical or otherwise, he was on deputation, so he
was
submitted
on
resignation.
He was on technical resignation from the university, Tezpur University. He is from Central Institute to Central University to be autonomous body Lordship. So Lordship may kindly pause for a moment that office number 59 Lordship.
You read number 2,
Mobility of-
clause 2 of 59.
Mobility of persons between central government departments and autonomous body Lordship.
Right,
Counting their service of pension Lordship.
correct.
Lordship.
So you have already counted his service.
We have already counted his service. Pension only he is entitled for pro rata pension Lordship.
No, how pro rata?
So,
You give him the pension in terms of which rules?
Lordship may be Lordship kindly page 60 Lordship.
No. The
Page
page,
60.
these are office memorandums. What is the parent rule?
Parent rule Lordship, pension rules, parent rule. This particular office memorandum is on the basis of the rule Lordship.
Which rule?
That that pension manual Lordship.
I know, but which rule in
CCS
particular?
pension rules Lordship.
Which rule in particular? Rule 5,
Lordship, rule 27.7 Lordship.
rule 27.7.
27.7 Lordship. Page
27.
71 Lordship. Counting of past service on submission of technical resignation on or after 1/1/2004 by employee governed by the central CCS pension rules.
Governed by the CCS control.
It is by
This is
CCS.
There is no controversy regarding that part.
No.
Issue is that
No. First you answer the question.
Lordship.
An employee for whom the CCS pension rules
Lordship.
covers their case
Lordship.
is required to be paid pension under which particular rule?
Lordship, as per Rule 26, Lordship, CCS pension rules, Lordship.
26.
As per here, Lord, 27 will be applicable, Lordship.
27. What does
27,
27 say?
27, 71, Lordship, page 71, Lordship.
71. What does it say?
Counting of past service on submission of technical resignation on or after 1/1/2004 by employee governed by the Central Civil Service Pension Rules 1972.
See, this is a government order explaining the position.
Lordship.
But where does the right of a pension accrue under the rules? Under which rule? There must be a particular rule where it
Lordship,
says that you are entitled or not entitled to pension. Is it Rule 5?
Rule 5, Lordship, Rule 5.
So read Rule 5(1).
Lordship. Regulations of claim of pension or family pension.
Right.
Any claim to pension or family pension shall be regulated by the provisions of this rule in force at the time when the government servant retires or is retired or is discharged or is allowed to resign from
Allowed
service.
to
or that.
resign.
He was not allowed to resign from service. He was on a technical registration on permanent absorption of a autonomous body loss.
Whatever it is, he submitted his resignation,
His
you have
service period
accepted.
is- Lordship, autonomous body service period is a continuous process, Lordship. He is after resignation of the Tezpur University, if he is Lordship not absorbed in that particular autonomous body, that it will be applicable, Lordship. Otherwise, Lordship, the 27(7) will be applicable for counting of past service, Lordship.
You
And
are
it was covered by the Lordship that.
You are saying that technical resignation is only to enable him to join in
Lordship.
join in that particular.
Join in that particular post, Lordship. Permanently absorb in that particular post.
You show us under what, how do you interpret this technical?
That part
it will be
is
there
the-
in the FR.
Lordship.
FR.
FR to time not being Lordship.
We have, if you
Lordship,
want.
Lordship.
Mr. Cholia, he is trying to call out an issue that ordinarily this is not a resignation per
Allowed to
se.
resign, my lord. He's allowed to resign.
No, correct. He is allowed to resign
On what circumstances?
because because you cannot be holding two posts.
No, sir.
Initially, you were on lien,
I was on lien.
and
when my
then
lien
you
period
decide
completed,
to
on that day I resigned. And they
you resign.
executed the order.
No, you resign not because you want to sever your resignation. You want to put an end to your
Service period.
relation as a master servant, but you are changing the nature of employment. From one institute, you are going to the other.
No, immediately thereafter, my lord, because that for that reason, as I have stated, the annexure, my lord.
You show us, you explain to us the meaning of technical resignation. What is technical resignation? How different is it from resignation? Mr.
I also
Gogoi?
have Lordship.
No,
Any other day.
but we do not find anything, my lord.
Any other day, I also apply. Otherwise, Lordship, he cannot hold two lien, two post, Lordship. The settled position of law.
No, his case is very simple.
Lordship.
Under Rule 5, you have been resigned. Technical or otherwise, whatever, he's been allowed to
Yes,
resign.
I'm allowed to
Other Rule
So
5,
now
there
once
is
he is
no mention
resigned-
of Lordship technical resignation. It's
What
for
is-
resign from service. Lordship.
What is technical resignation?
Technical resignation for a Lord facilitate him to join the another department, Lordship.
It's as good as resignation.
It cannot be
I'm
treated as a
resigned from
resignation.
the service.
You show us.
It cannot be. Lordship may give sometime. I will go to it, Lordship. Otherwise, Lordship, then Lordship, everybody can from one post he resign, permanently absorb another post, he get to benefit that post also, this post also, Lordship.
I
That is
stated
not the issue.
since
Even Lordship in
that-
Dhanbad also he has technically resigned. After technical resignation has submitted, he was absorbed in our institute. Accordingly, Lordship, Dhanbad has sent the prorata pension to us, Lordship.
You give us, where have you stated all that?
Lordship, regarding Dhanbad had given everything, all we have stated, Lordship. Dhanbad has sent the amount, Lordship. Lordship, paragraph 8, page 45 in our affidavit, Lordship.
45.
They have already sent us that amount, Lordship.
And now when
Page number 63.
Page 45 it will be, Lordship.
What is 63?
Page 45, Lordship.
Have a look at 63.
63, Lordship, calculation sheet, Lordship. In statement we have in page 45, Lordship. Page 45. On request made by Sri so-and-so to Indian Institute of Technology, Indian School of Mines, Dhanbad, Bhait is letter dated so-and-so. The Dhanbad Bhait letter dated so-and-so granted pro rata pensionary benefit amounting to so-and-so and remitted the same to the Tezpur University. It may be noted that despite the service of more than 18 years rendered in the Mr. Singh at Dhanbad, IMS Dhanbad has not granted monthly pension and retirement gratuities to Ashok Singh. Rather, they have granted the pro rata and discharge pension loss. More than 18 years.
So
Lordship.
you also have the option to apply for pension at
Pension
Dhanbad.
from Dhanbad also, Lordship.
You have rendered 18 years of
18
service
years,
there.
Lordship.
No, I will get the pension at the highest rate. At the end of the career, I will get pension. I would have got pension there.
No, you would have got pension, but you have submitted resignation there also.
Yes.
Then also he can apply here.
Then when I submitted resignation, I have been released from here only on submission of technical resignation.
You show us the what is the effect of technical
Lordship,
resignation.
Lordship. We give some time, Lordship. I will, Lordship, research it, Lordship. Otherwise, Lordship.
Let us understand this issue.
Otherwise, Lordship, he can pay for pension, Lordship, not only Tezpur University, another 4 institute of the central government. IMS Dhanbad, before that, Lordship, SG, before that, UP government.
No, AG and there only
they have
3 years of service I had.
We have also 6 years less than, Lordship, the required pensionable service. If we are not counted, Lordship.
And made the order.
What is the qualifying service? 10.
10 years, Lordship.
10 years.
10 years. 10 years, Lordship. 10 years. As per service jurisprudence, Lordship, when the lien is shifted to, Lordship, the other department, the burden not with us, Lordship. It's burden shifted to, Lordship, nearest, Lordship. Not with the
Let us understand this. Let us have a look.
Lordship, Lordship.
Mr. Cholia. Technical resignation.
The end period, that seniority I will get. They have counted also.
Why lien is given, Lordship? Then why lien is given, Lordship?
No, see,
It's
if
not
you
a
have
direct,
if you have
direct
worked
entry,
for
Lordship.
if you have worked for 18 years in Dhanbad and you are also allowed to give technical resignation, then you are covered by Rule 5 also.
My lord.
In Dhanbad, you had been allowed to resign. So the same argument will apply in respect of Dhanbad also.
Because in Dhanbad, after resigning from Dhanbad, I have not retained the retiring age. So I continued my service.
No, either you superannuate or you resign.
Yes.
You can't do both.
Not necessarily. No.
So you have the option of both actually.
Even
So
here
if you
also-
resign, then Rule 5 is applicable. If you superannuate, then also Rule 5 is applicable. So you have put in your resignation in Dhanbad. So in terms of Rule 5, you have that option also.
I had that option, but because I am continuing in service, I am not taking pension. Because I cannot,
Lordship.
that will be under the service rules, that will be again illegal. I cannot take pension and then continue in the government service again.
If truly speaking, Lordship, this litigation is not arise. If he was, Lordship, not dismissed from the nearest court, he would have some unscrupulous act, Lordship, he was dismissed from nearest. So
Whatever, that is not the issue here.
Lordship,
That is
just-
not the issue.
it is
Not the
so we have stated in our. Otherwise, Lordship, give some time. I will, Lordship, research it, Lordship.
You show us the status that
Lordship, Lordship, I will
technical resignation will entail pro rata pension only.
My difficulty will be, I will be away for a month.
We'll have it after a month then. January?
First week.
January.
January first week.
All right.
Singapore.
Matter be listed again. When do you want it? Give us a date. Give us a date.
আপোনাৰ সুবিধা মতে লওক আপুনি আহি কেতিয়া পাব সেইটো খেলক একেবাৰে ফাৰ্ষ্ট উইকত নল'ব ছাৰ একেবাৰে ফাৰ্ষ্ট উইকত নল'ব
On 9th of July, 9th of June. January.
9th of January.
Lordship.
Is a Tuesday.
9th of January.
Madam.
Matter has been heard. Mr. K. Gogoi, learned CGC.
Lordship.
Praised for some time to apprise the court on the question of technical resignation and its applicability
Lordship.
in respect of the petitioner. Technical resignation within courts. Insofar as his eligibility for pension is concerned.
Lordship.
He prays for some time. Prayer is allowed. Matter then referred to 9th of January 2024.
Oblige, Lord.
9 January.
Madam.
Yes.
I'm referring to.
Huh?
Oh, 27.
Yes, who's for the respondent?
Mr. P. Decca is for the respondent. He's on his legs.
He's on his leg. So here is a question where you were downgraded.
Yes.
Then not informed, you filed an appeal. The appellate authority is the accepting authority.
Reviewing authority, accepting authority, first appellate authority, same person.
All same.
All same.
So now, what is the relief that you seek for?
And thereafter, I filed my appeal before the DGP. DGP also rejected without application of mine. And my lord, if your lordship kindly come to page 47, my lord. After this petition.
37.
47. This is a part of the HCR, my lord. So we will see
Some date, something to do with the date.
Yes, the reporting authority graded me very good. Then the reviewing authority tick marks under the good column, that is, he has given good. And signature is of Mr. M.P. Nathel, Inspector General of Police Operations. And dated is 2/8/2011. So kindly come to the next page. This is the accepting authority remark. Graded as good,
same person.
And date is my lord 1/8. And I have prepared 2 appeal. They have filed an affidavit in opposition. Nowhere they have taken the stand. This is by inadvertence. This date has been recorded. So how can I accepting authority first record and then review my? And
Yes.
As far as my lord, one more point. There is a my lord standing order number 56 in force, and that says it is the IGP administration who will be the accepting authority, not the IGP operation. So to that extent also it is without jurisdiction. So
IGP
administration.
Who has to be the accepting
Yes,
authority?
kindly come to
Reviewing or accepting?
Accepting. I'll just present. That will kindly come to page 51.
51.
This is the standing order number 56, their own order.
Yes.
Subject is preparation and maintenance of annual confidential report. Now, Lordship will kindly turn to page 54, the relevant portion.
Yes.
Clause 6.1.1. 6 says initiation of maintenance of ACR. 6.1 is a procedure for initiation and transfer. The ACR should be initiated in duplicate by the commandant principal AIDG being the controlling officer of the respective unit, establishment, institution, as the case may be. The admin ACR will be sent to range DIG and the operational ACR to the operational DIG. The range of DIG, after endorsing their remarks, will forward both the copies of to the admin IGP. The ops IGP at the end of the year may, if need be, forward his appreciation, impression, any worthwhile achievement, misconduct, or slackness, etc., in the performance of any officer in writing to the admin IGP, who in turn would take this into account while endorsing the ACR as accepting authority. So it is the IGP administration who has to be the accepting authority as per this standing order. So the other point is, my lord, that the IGP operation without any jurisdiction acted as the accepting authority. On this count also, VCAT. So my humble prayer before this honorable court is that the matter has to be remanded back, this assessment to be redone, and a review DPC has to be, because
Yes, what do you say,
on
respondent?
the basis of this, I have been found unfit for promotion.
Yes, respondent.
But actually, in this matter, I am not engaged. So, Mr. R.K. Dev Chaudhary,
I-583, Mr. R.K. Chaudhary was appearing in this matter. But Lordship, today morning, suddenly he had some back pain. So today he is not available. So petitioner may complete his.
He's completed. He's just refreshing our memory.
He submitted that. It
Yes,
cannot
sir,
be.
already submitted. I think there is. On the last
So we are only waiting to dispose of the matter. That's all.
Lordship,
Huh?
the Lordship has already heard. I mean, as per my instructions, Lordship has heard the respondents on the last day.
We have heard, but we would have appreciated if our memory from the would have been refreshed by the respondents as well. Do you want to say anything, submit anything on this?
No, Lordship.
When is he likely to be back?
Lordship, today morning.
See, we are disposing of these matters. We are not calling for written argument. So at least the submissions ought to be recorded correctly. So therefore, that was the whole idea of keeping
No, yes,
it,
Lordship.
making it available for disposing it of.
Lordship, suddenly it happened this
No,
morning.
that's all right. That's all right. There's no problem there.
Lordship, yeah.
We keep it on Tuesday then. Tuesday? 28th?
Lordship, not on 28th, Lordship. 5th December, Lordship. Tuesday, Lordship. April 9.
5th. Then on that day, we don't want Mr. Deka.
My
He
lord.
should be available on 5th.
Yes, my lord, I will be available, and I am also ready today to do my part. But
Is it not interconnected in a way?
It is not exactly interconnected, but the petitioner is same.
So better to pass it together.
Yes, my lord.
5th.
That would be better.
Lordship, I'm very sorry, but it's unfortunate, Lordship. Today morning only.
No, you don't have to be sorry. It is okay. We are only asking you for the date.
Yeah, Lord, because after going today only, I will.
We could have disposed it of right now, but the only question is that we thought we'll better to do it in the presence of the council.
Yes, Lord.
So that there is no overlapping of or incorrect recording of facts.
Yes, Lord.
Because admittedly, petitioner has made out a case that his ACRs in terms of the law laid down by what is that? Devdutt has not been. He has a right. He's filed an appeal. Appeal and all these are decided by the same authority. There is no ground for supporting this ground. Why that gentleman has to be reviewing, accepting, and appellate authority. So that's the only issue. And in your matter, the question of stoppage of increment
Stoppage of increment at
for 2 years.
2 years without cumulative effect. Then it was a penalty. After the penalty is over, they have given me the next day. The 2 years. Next day they have given me the promotion. And in the affidavit in opposition, they say that during the pendency I was found fit, but they have adopted seal cover method. So they opened up the seal cover and given me the promotion on the next day. So I am praying for counting of the seniority during that period in terms of a OM. And Lordship wanted to have a judgment of them. Lordship wanted to have a judgment citation. I got the petition. It's very clear that Honorable Apex Court has clearly indicated paragraph 6. I have prepared the gist of the case also. The paragraph 6, my lord.
Para 5 perhaps. Start
5 and 6.
Yes. What is in, please read, para 5.
Paragraph, yeah. Only point that is involved in the appeal is whether the board was justified in confirming the appointment of the appellant for the post of assistant engineer class 2, which effect from December 1, 1969, and placing him below the juniors, namely respondent number 2 to 4 to 19, the seniority list. As has been noticed already, there is no material to show why the appellant was confirmed in the post which effect from December 1969, when he has completed the probationary period of 2 years satisfactory. It is submitted on behalf of the board that minor penalty was imposed on the appellant by stoppage of his increment for 1 year, and he was confirmed with effect from December 1960 below respondent number 20. We are unable to accept the above contention. The penalty was imposed on April 15, 1960, as a result of which he was deprived of monetary benefits of 1 increment for 1 year. The penalty by way of stoppage of 1 increment for 1 year without any future effect. In other words, the appellant's increment for 1 year was stopped, and such stoppage of increment will have no effect whatsoever on his seniority. Accordingly, the board has acted illegally and most arbitrarily in placing the juniors of the appellant above him in the seniority list and confirming the appellant.
Have you seen this judgment, Mr. Deka?
No, I have not seen this.
This is exactly what he is urging.
May I ask for the citation of this?
We'll keep it for all right, further hearing or further orders or whatever on 5th of December. You go through the judgment. I think nothing more is required.
And OM is also there.
But my lord, I have only one request. I might be little late, but after 12, I will be available in this court. But we will surely, I will surely accommodate the court.
Request your colleague to
Yes, my lord.
invite court to take it up.
On that day, that may not occasion also, but
Yes, you are otherwise busy lawyer in the
no, my lord, I am
trial
not at
circuit.
all
We
busy,
are
but
aware of that.
sometimes matters used to flag.
Yes. All right then. Tuesday.
No, let it
Sorry.
be fixed on 5th.
5th of December. 5th of December. For orders. Please make a mention in the court that it is fixed for orders.
Yes,
because
my lord.
we will lose track of that.